What are the 5 serious consequences if you sign a Section 9 statement during a criminal investigation in England and Wales? If you are a witness, complainant, or a victim and you have been asked to sign a Section 9 witness statement, please watch this to the end before you sign the statement. You see, signing a Section 9 statement is something that so many people don't fully understand the consequences of until for some it's too late. And from the outset, let me make 2 points very clear. Firstly, if you want to cooperate with the police or a defense lawyer to be part of the criminal proceedings, to bring someone to justice, to convict a person, or to support justice to acquit a person, that's your choice. And a lot of brave people have come forward to help put dangerous people behind bars or to help free an innocent person. So respect to you. And let me also be clear on the second point. You should never, ever feel pressured or intimidated by the police, defense lawyer, or anyone to sign or not to sign a Section 9 statement. Again, remember, it's your choice. So what is a Section 9 statement? A Section 9 statement is a written account given by a witness under the Criminal Justice Act 1967. The content of the statement contains a declaration by that person to the effect that it is true to the best of his knowledge and belief, and that he made the statement knowing that if it was tendered in evidence, he would be liable to prosecution if he willfully stated in it anything which he knew to be false or did not believe to be true. You could be asked to sign a Section 9 statement if, for example, you are a takeaway worker who has witnessed a theft by a person who has run out without paying, or you are a taxi driver whose car has been damaged by another vehicle being driven dangerously, or you are a victim of domestic abuse assaulted by your ex, or you are an alibi witness for a defendant accused of being present and involved in a serious assault against another. The Section 9 statement is often drafted by a police officer as part of the investigation, as in the first 3 examples given, or drafted by a defense lawyer, as in the last example given. But please remember, in the end, by signing the Section 9 statement, it is your statement of truth, whoever has drafted it. Now, if you're asked to sign a Section 9 statement, you need to be aware of the following 5 main consequences. 1. Once you've signed the Section 9 statement, it becomes official evidence in court proceedings. That means it's part of the case proceedings and can be used for or against any defendant. Your name and other details will be known to the police working on the case and the prosecution lawyers, and in the vast majority of instances, to the defense lawyers, the defendant, other witnesses, and even the press too, eventually, if the case is a high-profile one. 2, by signing a Section 9 statement, you may be summoned to attend a criminal trial. While a Section 9 statement is designed to avoid the need for your appearance at court to give oral evidence, if the defense or prosecution challenges your Section 9 statement as evidence, you could still be called to testify at the trial. So please don't assume that by signing a Section 9 statement means you'll avoid court altogether. And moreover, even if you withdraw your Section 9 statement with another Section 9 statement, often called a retraction statement, stating you no longer want to cooperate with the criminal investigation and subsequent proceedings, that doesn't automatically mean the end of your involvement. You can still be summoned to attend court. More said about how to make a retraction statement to avoid court in another post. 3, if you are attending court or summoned to court, expect to be examined and cross-examined by one or more of the lawyers. This can be a nervous and tough experience, especially if you're not used to a court trial. Lawyers on both sides, the defense and prosecution, may challenge your credibility and the accuracy of your Section 9 statement, which is likely to be the lines of attack. 4, your statement and evidence could greatly influence the entire case. It might help convict or acquit a defendant. The stakes are potentially very high, and the implications of your evidence could have life-changing consequences for others. So seek help for your mental health if it's been affected by such pressures. And 5, and perhaps most critically, you will be punished for blatantly lying in a Section 9 statement. If you knowingly give false information, you could be prosecuted for either wasting police time or for the more serious offence of perverting the course of justice. Both offences carry serious penalties, including prison sentences. So it's vital that your statement is truthful and accurate to the best of your knowledge. And if it's not, don't sign it. So to conclude, if you've been asked to provide a Section 9 statement, it's essential to fully understand these 5 consequences. If you are not sure about signing a Section 9 statement or you feel pressure to do so, seek independent legal advice. If you have signed a Section 9 statement and want to withdraw or retract it, then please speak to an independent lawyer not connected to proceedings to advise and support you. More said about this in another post. Thank you for watching. Don't forget to subscribe and follow for more.